federal government has officially arraigned former Kaduna State Governor Nasir El-Rufai before the Federal High Court in Abuja. The charges follow his public admission during a televised interview that he had access to intercepted phone conversations of the National Security Advisor Nuhu Ribadu. Details of the charges, that's a lawsuit, includes the following counts. Count 1, unlawful interception of the phone communications of the National Security Advisor. It's said to be a violation of Section 12(1) of the Cybercrimes Prohibition, Prevention Amendment Act 2024. On count 2, that covers failure to report individuals known to have carried out the unlawful interception to security agencies, violating Section 27B of the same legislation. And count 3 involves deployment of technical systems in a manner that compromised the national security and public safety, contrary to Section 131 sub 2 of the Nigerian Communications Act 2003. Now, this case stems from, as mentioned moments back, an interview on television that was just on Friday, right, last week Friday, where Nasir El-Rufai claimed he was aware of an order for his arrest because someone tapped Ribadu's phone. Those were his words. He further alleged that the Independent Corrupt Practices and Related Offences Commission had procured the State Security Service to arrest him and, hand him over to them. Well, on the morning, just this morning, which happens to be the morning of El-Rufai's birthday, he appeared at the Economic and Financial Crimes Commission headquarters to address separate investigations into alleged financial misconduct involving 432 billionaire during his tenure as governor. As you can see there, that was when he was leaving his home this morning, and there were chants, as a matter of fact, hailings and birthday wishes, chanted at his home, his residence there. Meanwhile, back to the matter, the prosecution team for the wiretapping case is led by the federal government's prosecution team, and El-Rufai is expected to take his plea at the Federal High Court as his trial proceedings commence. Details of those will bring your way. Well, let's talk about this particular matter. There's been historically there are cases related to wiretapping in Nigeria, and that's been a tool for political mudslinging rather than a basis for litigation, as we are seeing in the case of the former governor of Kaduna State. Well, let's just lay the foundation before we get talking with my guest. Just a little foundation. We have a past precedent, right, regarding this one. Previous incidents such as the 2017 Mechi tapes or various leaked conversations of governors during election cycles were typically dismissed as, clone voices or political propaganda. We had one even in the build-up to, I think, post-2023, there was one as well. Well, this kind of things rarely led to charges because the Cybercrimes Act 2015 was seldom tested against political elite. But there's a different one now. There's a different case, a unique situation with Nasir El-Rufai on this particular charge. Unlike past cases where the leak was the evidence, this particular case is built on the defendant's televised statement admitting he listened to calls. This moves the legal needle from proving who did this to punishing the admission of being an accessory. Well, I'm joined now by the barrister and solicitor of the Supreme Court of Nigeria, if you like, constitutional lawyer, Vance Feli. He joins me virtually for this conversation. Many thanks for joining me today.
Very well. Thank you.
Appreciate that. Well, we have on our hands the state-sponsored criminal prosecution against a former ally of the ruling party. How time flies, how tables turn. Did you see this happening? I know that conversations happened when several conversations happened, even on the morning show. regarding this that is conversation. But it's been what's barely few hours, and there's been charges filed. Let's get your thought on this.
Well, I saw this coming because I know that the federal government want to take drastic action against El-Rufai, not principally because of the interview he did with Arise TV prime time, where he aired his view on the issue on that reference. Not principally so. This charge is more political, very politically orchestrated, because we've had conversations in the past which were dismissed, conversation from elite. The one between the CBN governor then and some persons, the one between Wike and the INEC officials during the elections, and also the one between Rotimi and Mechi and some other persons where it was saying this country is going nowhere, and they were in government then. So all those ones were discharged as clone voices, AI orchestrated, motivated voices and all that. But in the case on that reference, the reason that charge cannot fly in the law court is because that charge is very defective, very, very defective. I read it, and you see, El-Rufai did not say he tapped the phone line. If you look at one of the charges there, one of the charges is saying that he tapped the phone line. They cited provisions of law to the effect that he has contravened. He didn't say he tapped any phone line. He said someone did, and he listened to that. Someone supplied him with that, which he listened to. Well, the count charge on conspiracy, that particular one can stand. But the one that he tapped, no, cannot stand. And when you look at it, can you charge a man fully for statements he made when he was not under caution, under criminal prosecution? It wasn't under caution, it was an interview. Okay, can you charge a man for such statements? When the Constitution, his rights under the Constitution, self-incrimination can be cited as a defense. Okay, so I see that this is a charge under criminal prosecution counts and cumulation of allegations, okay, for which the prosecution can use to arraign the defendant before the court. The defendant will take his plea, and the defendant will be granted bail. Then he will be remanded in prison until he meets his bail condition. I think that's what they want to take him through. They want to take him through that, the rigors of that. As for the substance of that case is dead on arrival. It's dead on arrival because if you look at the charge sheet is not expressing law. It's only one among the charges that look like something that can be tested. Every other part of it is does not hold water at all.
Even though sections of several legislations were quoted in the 3 counts.
Yeah, I can see. I know the sections quoted. One borders on conspiracy. That is, he was stabbed by someone and he got involved. Okay. One is said he tapped. Okay, and all that. So until we get to court, but from the look of things, from I'm not a fan of El-Rufai, but I think this is just politically motivated. It's a case of witch hunt and all that. Because when you dig deep into this issue, this same APC government that is charging him did all this during the Jonathan regime. Okay. Using all sorts of anti-national security measures to ensure that Jonathan does not return, including bringing bandits and criminals into the country, which El-Rufai was at the forefront of that. Okay. So that same game that we played to bring the APC to power is the same game he's playing against them now. And they're not able to take it. They're not able to take it. So that is the most unfortunate thing about the entire situation as it were. This is not to say that what El-Rufai did was right. No. Don't get me wrong. I do not support any action directly or indirectly, that undermines national security or that jeopardizes our sovereignty and put Nigeria at the verge of dangerous situation. I do not subscribe to that. However, this conversation cannot be complete if the sins, of the prosecution is not accentuated alongside the wrongs of the defendant. Okay.
Let's.
Yeah.
I don't know that this has been filed, and we're not to discuss the substance of the matter. Let's just examine some, legal, if you like, some technical side to this particular case like this, particularly for legal education, so that Nigerians can further learn. And maybe we'll begin with the admissibility of the confession made here. Well, in this case, the prosecution's case relies heavily on the statements made during a televised interview, and under the Evidence Act 2011. I'd just like to know, can the public media interview be treated as a formal confessional statement, given it was not made under caution? And how does the court then distinguish between a direct admission of guilt and a mere narrative of fact? I know you alluded to that a little bit, when you were talking about in your opening comments, but let's get deeper into that.
Yes, an open confession. A confessional statement is one that is made under caution, okay, wherein the defendant had been so informed of the implication of his statement before the law enforcement agency and all that, okay, where he declines making such statement. He has a right to sue until his lawyer arrives. Okay, so I've answered that before, that that statement was not made under caution. Okay, it cannot be termed as confessional statement under the law because it was a narrative that that came out from a question asked by the presenter, and so because the person in question, interviewee in question is one that has fell out of favor from the government of the state. Okay, it is now an issue. Okay, it's now an issue. And not to say this government does not know that that used to be their practice, but that now that there's a reversal of fortune and they are now the receiving end, perhaps this is the time they want to use to exercise. Now they are now talking about national security. They didn't talk about national security when they all conspired to bring in criminals into the country. They didn't talk about national security when they had to do everything within hook and crook, every means to ensure that they supplanted the PDP government at the time. They didn't talk about national security. They didn't talk about national security where El-Rufai himself said he has gone to pay criminals, not to attack. They didn't talk about national security all the while. Okay, where when they pray at the military camp, they pray, and some insurgents come to pray also at the same place. They didn't talk about national security and all that when they pay ransom to insurgents to have our guests back in situations of abductions that have taken place and in several occasions. They didn't talk about national security. Okay. Up until when Americans have to intervene and all that. But they were quick to go and pay $9 million to an institution to make Nigeria good in the eyes of the world. So, the best form of national security they ought to accentuate is to ensure that they take care of the issues under reference. He can be invited, okay, by the security agencies, profiled, okay, and let him now make proper confession as to who really tapped the communication of the National Security Advisor, the phone, who did that, when, how, under what circumstance. He can be used as a tool for investigation. But not that you say you are charging him because he said something that someone tapped and he was privy to the information and all, and therefore you are charging him. We are even saying in the charge sheet that he's the one that tapped it. And he went further to say that he you know, abated it and all that. When you know that the conversation itself is not one that was under caution and the rest of that.
How about count 2 of that charge, which cites section 27B of the Cybercrimes Act regarding the failure to report the known interception, right?
Yes,
Knowing that someone did this, claiming too that it was presented to you, you heard, knowing that that's definitely illegal to do. In a case where the defendant claims, oh, it was merely the recipient of information from the source that was not named. What's the legal threshold for proving knowledge of the perpetrators versus, simply receiving the end product of a hack?
Yeah, that charge is the only charge I see that's credible, because if you have such information, the law says you should report, and in the event that you don't report, you become an enabler. Okay, that particular section is the only one I see that's credible. That's a charge, that particular charge. But you see, there's also a defense to it. There's also a defense to it, to the extent that he did not say how we got the information. He didn't say under what circumstance. He didn't tell us whether it was given to him or he stumbled on it. Or he didn't say that. He just said that he got it. He got it. The way he got it is a different. We don't know how he got it. Okay. Now, under what circumstance are you supposed to report? When you were told by someone, or when you stumble on it, or when you find it solely, or what? Under what circumstances are you supposed to report? Okay. So that has to be interrogated. Really interrogated. Okay. And that must be done under strict legal proceedings. Okay. So this case has to go to court, has gone to court already. Like you said, we're not talking about the substance. We're talking about what is possible under the law, or what is not possible. Okay. It's not our duty to begin to sit as a court, okay, when the matter is already before a court of competent jurisdiction. But there's no law that says we cannot talk about the issue. There's no law that says, in fact, the law compels the media to talk about the issue. The law compels the media to talk about the issue. And so the media is fine and safe. But the law didn't say the media should usurp the authority of the judiciary. And that we have not done so far. So we're only looking at what is possible under the law and what is not, for general knowledge and for the purpose of the case under reference. So at what point can you say that the person who gets a particular information ought to report? Under what circumstance is he supposed to report, and the rest of that? So those are issues of law. Those are issues of law that will be determined by the court.
And it will be very, very interesting to follow the proceedings in court to see how things would play out. But you have said that maybe this would be that long drawn out game where the defendants will be remanded, given stringent bail conditions. It might take time to meet those bail conditions and the rest, and maybe that's the political side to this. But that is yet to be seen. We've seen maybe this in the past happen. Maybe even further charges will be filed. Maybe it will be amended. We cannot say now. But let's talk about one more thing before as we begin to wind down the conversation. Let's talk about prosecution powers and even jurisdictional technicalities as well. On the charge sheet, it is clearly stated there the federal government of Nigeria. But there are debates around. As a matter of fact, it is reported that this was filed by the State Security Service, even though the file charge carries the federal government. So there are debates around that, about the State Security Service initiating this criminal suit directly. Now, does the National Security the National Security Agencies Act or the Cybercrimes Act grant the State Security Service the specific legal standing to prosecute these charges, such charges as this, or should they have been filed by the Office of the Attorney General of the Federation?
The secret, the state secret service have no powers under the law, have no prosecutorial powers under the Nigerian law. That is why I tell you that the SSS, they are overstepping their bounds. They don't have such prosecutorial power under our laws. So it is foolhardy to see that they are now the ones, prosecuting the matter, as it were. Okay, they are even prosecuting the matter under the wrong status. They are not even applying their name rightly. They are using the DSS, Department of State Security, which is not what they are called in the constitution that created that institution. It's Secret Service, State Security Service, SSS, not DSS. So you see, the defect in that charge is enormous. But
there, possibly the technical glitch there, stopping my guest, constitutional lawyer Vance Tufeli, from making his thought known some more. As we talk about this and begin to wind down the conversation, we've been talking about this charge filed today by the federal government against former governor of Kaduna State, Nasir El-Rufai, over comments he made on television during an interview just a few days ago, saying that he, listened to the conversation, meaning, a private conversation by the National Security Advisor. He did mention that he listened to that, and in that conversation, he knows from the conversation that the National Security Advisor, Nuhu Ribadu, orchestrated his arrest. That's the attempted one, did give directives for him to be arrested. And that's first sparked several thoughts across platforms. But, while he was celebrating his birthday, he, he's received several wishes from different corners. In fact, the videos which we played you of his supporters and lovers, right there, you can see on your screen videos of his supporters, of his lovers, friends and families, political allies there, storming his home to wish him well. In that video, they sang and chanted, birthday wishes for him. Well, he did proceed from there to the the headquarters of the Economic and Financial Crimes Commission, and just moments later, not so long from that time, a report of the filing at the Federal High Court in Abuja. This charge, 3 counts precisely against him, happened. Well, let me let you know those counts one more time. Hopefully we can reconnect with my guest today so we can wrap the conversation. So we do so. Let me let you know what counts those were. 3 counts precisely, that the federal government filed against the National Security Advisor. As you can see on your screen, that's count 3. You can see there. Let's go to count 1 and 2, which you'll find right there on your screen in just a moment as we show you again how that happened. Yeah, beginning with count 3, there was a, okay, there you see count 1 right there. Let's begin with count 1, as you can see on your phone. The summary of that is, first it's quoting section 12, sub 1 of the Cybercrimes Prohibition, Prevention, etc. Amendment Act 2024. And they, that is essentially, about around that particular section. And then in count 2, there was a failure to report individuals known to have carried out the unlawful interception to security agencies, and that is said to have violated section 27B of that same legislation. In count 3, What we see in that charge sheet is the deployment of technical systems in a manner that compromise national security and public safety, contrary to Section 1312 of the Nigerian Communications Act 2003. Thankfully, I'm rejoined by Barrister Vance Feli, my guest on Homo Politicus today, as we wrap the conversation. So you were just talking, very quickly about the, this matter around jurisdictional technicalities, prosecutorial powers as well of the State Security Service to have filed this one, rather than the Attorney General of the Federation. Your final thought?
Yes. What I'm saying is that there are very jurisdictional issues, technical jurisdictional issues that arise from the interface of what have been seen. The DSS have no prosecutorial powers under our laws. First, we won't start with, okay? And they have also brought this charge sheet under a wrong nomenclature, okay, using the DSS. So these are defects that can be challenged under a no-case submission, where a no-case submission can be filed to the effect of all these defects, okay? And like I said before, this is actually what the federal government ought to do when issues like this happen. And don't get me wrong, they ought to take action, okay, and prosecute whoever is involved. But the prosecution must be done well. The charge sheet must be done because the case is either lost or won from the beginning, from the charge sheet. Okay? Now, all these defects put together have the tendency and proclivity to make the federal government to lose the case under reference. So we're looking at just what is possible and what is not under the law, and to educate the public as to the veracity of the actions taken so far and whether such actions are within the bounds of law and how they conform to the issue under reference. Largely, from investigation, a criminal case can be lost or won from investigation. And this is to also let the public know that the safeguards and the constitutional rights of the defendants are critical here, okay, which has to do with the fact that statements, confessional statements, ought to come under certain form. And in the absence of that, there are legal implications that follows. Okay, so the federal government should go ahead with what they have put together, bearing in mind that the defense, okay, will challenge the prosecutorial power of the State Security Service to undertake this tax. They will object to the nomenclature use. They will object to, they will put forth an objection as to the defendant's constitutional safeguards as it relates to confessional statements. And many other sundry issues will be raised. So it's not just Uhuru for the federal government, but they will have their day because they will take him through, after that arraignment, they are going to remand him in prison custody until he meets the condition of his bail. Definitely they will grant him a bail, the offense is bailable and all that. But what I will say is that this case should not be politicized. The federal government should not turn this around against political enemies. This case should be dealt with on the merit of it, on the face of it. And that merit is what is required. So they should go ahead and prove the case. The prosecution, other than what the defendant has said, the prosecution will need to prove his case beyond reasonable doubt. And it is not allowed that he must rely on the weakness of the defendant's case. He has to prove, okay, beyond reasonable doubt, and inculpate the defendant clearly on merit. He must inculpate the defendant clearly on merit.
All
and
right.
not on the basis of political settlements and whatsoever.
All right, let's leave this to wrap the conversation. We'll leave this particular matter, though closely tied, still about the former governor of Kaduna State, Nasir El-Rufai. Well, he, today is his birthday. He appeared before the Economic and Financial Crimes Commission. There were protesters there, both those supporting him, his supporters, and then those who definitely were there to protest, demanding that justice be done, that he be tried, and that the law should take its course. So protesters on both sides, those in support, those against, were seen. And there were allegations of, some restriction for some protesters. As a matter of fact, the one who claims to be the supporter of the former Kaduna State governor said they gave access to those protesting against El-Rufai and then restricted them access. What do you have to say about this entire scheme, the entire picture, not scheme now, the entire picture, what's happening, particularly as we approach proper electioneering? Just last week, Friday, the chairman of the Independent National Electoral Commission, Professor Josh Namupiton, released the schedule, the timetable, which is now being debated. We hear that the National Assembly or the House of Reps will be sitting tomorrow to debate that might be part of what they'll be talking about. But yeah, the timetable has been released. By what March downwards, political parties would need to begin to work together to put their house in order to produce candidates across several positions. Do you think this is politics, playing out, or there's some genuine move to bring to account the former public official, in person of the former Kaduna State Governor Nasir El-Rufai?
Yeah, you cannot rule out the influence of politics in this. I said this before. If you look at what is going on, he made a vow to make sure that Tinubu does not return. Okay, he said it. And he also had said what they did in the former, during the election of even that brought Tinubu into power. Yes, I don't know that you are aware or privy to the documents he released where he said P2B won the election. And he said what they did. You understand? His son in the house, okay, also alluded to the statement that if election were free and fair, before 12 noon, Obi would have won the election. He said that, so it's on record, it's in the media and out there. Ever since then, there have been, the APC have been unsettling, okay, on those issues. And so, going further with this interview that borders on national security, it's just the issue that broke the camel back here, and the APC, the federal government rather, is now up and against him with a charge. Okay, I do not fault the charge preferred against him in the sense of the charge on national security. Okay, but what I fault is the composition of the whole thing and the institution championing this and all that. That will give the case, put the case in a bad light, because the party that is prosecuting this under reference does not really have the authority to so do. So,
all right, there you go. We'll just leave things there. We'll keep monitoring the development as things develop from here. What happens when the court sits, how the matters will go, what will happen further with the Economic and Financial Crimes Commission. Apart from this 3-count charge he needs to face now, he would need to be responding to questions from the Economic and Financial Crimes Commission about some funds from his time as governor of Kaduna State. So he will be responding to how he governed in those 2 terms. But yeah, as mentioned, we'll keep monitoring this alongside some other political matters tied around the former governor of Kaduna State. He's a key figure within the opposition bloc, the African Democratic Congress. As we saw with Malami, who happens to be the key figure too, we've seen something similar that in this particular matter. Well, time will tell, and we will bring those your way here on Homo Politicos. So you don't want to miss the next episode and the ones to come. Well, that's a conversation. I'd like to thank you so much, Barrister and Solicitor of the Supreme Court of Nigeria, Evans Ufeli, for joining me today.
My pleasure. My pleasure.
Appreciate that. That's Homo Politicos today. Well, may God continue to bless the Federal Republic of Nigeria. Kings.